your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
You need a little bit of Cool C to start off your Tuesday morning. Does the trick, and David Whiting does the trick as well. Melbourne solicitor sitting before me resplendent.
In the studio for the first time since July.
Shh, don't tell anyone.
Okay.
Just keep it between you and me.
We've been proximate, but this is in the same room.
That's right, yes. Hello.
Hello.
You've got homework.
I did. Sam from Tarneed rang, and Sam's mum and dad had died, and what he was doing was going through their financial records. And in the records he finds 2 cheques made payable to them. It represented the superannuation proceeds.
It was a lot of money.
Yeah, $40,000.
40,000, my memory says. Yeah.
The proceeds of his brother's superannuation. He died without issue, and so the super went to the parents, and they weren't cashed. And what was the question? And I ummed and ahed about unclaimed monies, and the answer is that there are essentially 3 places that you would look. Unclaimed superannuation is managed by the tax office. So if a superannuation trustee has super money and no one to pay it to, it goes to the tax office. It's matched to Sam's brother's tax file number. So if you can talk to the accountant or former accountant, get the tax file number, you can make an online inquiry at the tax office and they'll tell you what they've got. Right?
Okay.
Now, that's if it meets the definition of unclaimed monies. My worry was that if we're treating it not as superannuation money but money due to mum and dad by a business being the super fund, then that would be held by the State Revenue Office in Victoria. So I would be looking at both the tax office website, the State Revenue Office website. Both of them have no limitation period on repayment. So notwithstanding that the payments were made in 2007, the money will still be there.
Okay, so there's no sort of
No,
limitation.
there used to be. In Victoria, we got rid of it in 2009.
Yeah.
And in the Commonwealth, we got rid of it in about 2015.
Could you not just contact the issuer of the cheques and say, hi?
But that's where you would start.
Just to keep it simple, just say, look, found it, wasn't cash. Can I cash this one, or would you issue another one?
Cashing it's difficult. When a cheque is 18 months old, it moves from a cheque to a bill of exchange and
love that phrase.
Becomes somewhat messy. Yes.
Let's not do that then. So at least first make the friendly phone call. Could you please just reissue?
There's a catch though. What you'll find is that between 2007 and 2022, the business will have changed computer systems at least twice.
Oh, I see, right.
And won't have access to... Anyway, so start there. If you don't get what you want there, to talk to the tax office, and if you don't get what you want there, then it's unclaimed monies in the State Revenue Office system.
Okay. 1300 222 774 is the number if you'd like some legal help this morning. Carmen, you've called in from Malmesbury. Go ahead.
Oh, good morning, Virginia and David, and nice to imagine you sitting face to face. That's lovely.
Socially distanced, though, Carmen. Let's put this very clear. Socially distanced.
Of course.
Yeah.
Absolutely. David, this is a retirement village question.
Yep.
In 1993, my parents bought a non-participatory lease in a retirement village. They bought it for $103,000. Last year, when Mum passed away, the unit was sold and the incoming resident paid $685,000.
Yes.
So even if they spend $100,000 on refurbishing it, they've still made $500,000 on this transaction.
Yes.
Have I got any recourse to?
Well, first of all, Carmen, you need to consider what the business model is of a retirement village. And the business model of a retirement village involves getting paid additional funds upon the change of ownership of a unit, and you will often find that the unit value doesn't go up very much, but the retirement village still takes a chunk of the new price. Right? So the issue is it's the document that your mum and dad signed 30 years ago. That's the contract they signed. That's the one that's being enforced. Does it strike me as unreasonable? What strikes me as unreasonable in most of these models is that sometimes the cost of refurbishment is out of all proportion to the value of the underlying unit. I've seen ones where, the village is now going to have all of this kind of appliance, even though they're all perfectly valid and working functionally. So there are lots of them now where it's 3% of the value of the unit for each year.
So what can Carmen do?
Nothing. The answer is her mum and dad bought what amounts to a lifetime lease, and the lifetime lease ended when her mum died, and the unit now belongs to the retirement village, and they're entering into a new lease.
Carmen, that's it.
Right.
Maybe it's a Carmen. Your call today is a bit of a buyer beware to others who might enter into such a situation. That's how it pans out in the end.
I haven't seen a retirement village agreement that doesn't involve a substantial deferred management claim. Sometimes they're limited to 20 or 30% of the value of the unit.
Yep.
But I'm assuming from the non-participatory release that Carmen's parents waived their right to further income.
Sorry about that, Carmen. Robert in Malvern has an unusual problem. Go ahead, Robert.
Good morning, Virginia and David. Yes, I have one of the major banks insisting on giving me money that's not mine.
Do you not want to? Because they can give it to me if you like.
Well, I just want to know what the legal issues are going to be. Some years ago, they refunded advisor fees that they charged to my father's estate, and then 12 months later they tried to do the same thing again. I advised them it had already been paid. They looked into it, came back to me, apologised, and didn't pay us a second time. And now a third time they've contacted us again to say...
Robert, I administer estates from time to time, and I'm still getting cheques from a fund manager for advisor fees and service fees for an estate that was closed 8 years ago.
What do you do with the cheques?
Well, you end up sending someone a cheque for $8.
Right.
So
we're not still paying advisor fees. We closed that.
No, I understand, but if you look at what they did with the Royal Commission into the banks, there was a long discussion about people being charged for things that they did not receive. Charging an advisor fee. In fact, one of my clients' files was one of the case studies, and the answer would be these people are making, and I've got them from three of the major banks. They're just arbitrary numbers. We've overcharged you. Here's the overpayment and the interest.
But Robert says he doesn't want it. So what does he do?
Well, but the problem is they've already paid us. We've signed an acknowledgement acceptance form. They've put $25,000 into our bank account, even though I told them that they've already paid us. And
no, I'm inclined to believe, Robert, that there are further fees. Right?
I don't know how they could be, because we closed the account as soon as probate was granted.
Yes, we're going back. Banks are going back a long way. What you wanted, if you want to, you can talk to the Financial Service Ombudsman. I suppose from Robert's point of view is if he keeps the money and he distributes it to those people entitled under the will, what then?
So, Robert, you're concerned about the legal consequences. I mean, $25,000, wow, you'd take it if you could, right?
My two siblings say don't pursue it any further. We've told them, they've said they've got no record of it, and they've put the money in our account. I think, I know it's not our money because I got all the statements showing what the advisor fees were.
Robert, I would be, if I was doing anything at all, I would contact the Financial Services Ombudsman and say to the Ombudsman, this is the income I was entitled to, these are the monies, I don't think I'm entitled to it. Would you please get confirmation from the bank/insurance company I'm entitled to keep it? And then rely on that.
But, Robert, you've got some documentation somewhere saying, yes, we're giving you this money, you're entitled to it.
Oh, yes.
And I take it that over the life of the arrangement, the advisor fees never topped $25,000.
Well, that includes interest.
Yes, but you have no idea what the interest rate is. You have no idea about anything.
No.
Yes.
Yeah.
But I've got on the statements, I've added up all the advisor fees. It shows what we were charged on the statements. And it made sense. When they first paid us, it all made sense. It added up plus some interest. And that was 7 years ago.
Robert, it's an interesting problem to have.
Yes.
But take David's advice, hang on to any of that documentation, and if you care to, come back and tell us how it pans out. That's fascinating. Laurie in Vermont South, go ahead. Good morning.
This is Laurie here.
Yes, it is. Go ahead.
I wish I had that person's problem.
Yeah, I know.
I don't. I'm living in a house that has a paling fence all around. On two sides, they're falling down. On one side, there is a guy who has had a steel fence erected on the other side of his property, and he wants to have the same thing erected on mine.
Yes.
I don't want to have this big grey metal fence replace the paling one, and that being the only fence on my property that has. Sorry, that wasn't meant to happen. I don't want to have one fence like that on my property with the other two being paling. So can he impose that on me?
Laurie, two possible solutions. Oh, sorry. The technical answer is no, he can't. He can only conduct fencing on your common boundary with a court order or your approval. And if you can't reach agreement with him as to the style of the fence, then what you end up with is a magistrate will determine what an appropriate fence is in the circumstances. Now, having said that, I faced exactly this problem 6 months ago. Because we had a very little fence, and we decided we'd put a picket fence on the common boundary, and the people next door decided that they wanted a fence very similar to the one that your neighbour would like to put up. So we actually built our picket fence. We left their chosen model of construction as the fence on the boundary, and we constructed what we wanted inside our fence. So from their side, they've got particularly exactly what they wanted. And from our side, we have a picket fence and the particular
with a metal
fence...
background.
Well, with a metal background, but it's grey. We can't see it. So we've got exactly what we want. We've got a front yard with picket fences.
So is that a solution, Laurie? You don't want to see any of that kind of fence at all. Is that what you're saying?
Well, I don't.
Okay. Well, let's see how you can come. Can they come to some other solution?
Well, if they can't reach an agreement, then where you go to is the magistrate's court, and the magistrate court determines the fence and the contributions that you make to the fence.
If you can't figure it out between you, Laurie. So the magistrate's court is where you'd end up, and I don't think anyone's recommending that here, are they? That you go to court over a fence?
No, well, we did. A couple, not personally, but we've had a couple of long fence disputes.
Yes, well, we know that comes up again and again. Laurie, is that useful?
And so the magistrate has the right to say you've got to have a paling fence or you've got to have this steel.
The magistrate can determine the style of fence and the contribution. The two of you can't reach an agreement. You've got a person in the middle who says, I think it should be this kind of fence and you should contribute in these proportions.
Laurie, if you want to take it that far, that's how far you can go. Thanks so much. John in Ormond, how can we help?
Yes, I've got an interesting problem. Hi, David.
Hi.
We looked at my wife's driving licence the other day and we found out that, in fact, it had expired. So we followed up on this and found out that the licence had actually been suspended, basically due to an administrative error over a medical form. We'd received no notification, just wonder how we would have stood legally if, in that period, my wife actually had had an accident or, was encountered by the police for some reason.
She would have been guilty of driving while suspended or cancelled.
And there is no comeback on this at all.
No. Look, I'm trying to get to the cheapest way to solve the problem. It would be taken into account. It might be possible for Vic Roads to reinstate retrospectively, but I would have thought that at the very least it would have impacted any penalty that might be imposed, and it may well be that the penalty would be reduced to nothing. Okay. But I have a similar story, John. I had a friend who was, say, A. Smith, who had a son, A. Smith. A. Smith, the son, did something horrible and got his licence cancelled, but because of the way the licences were recorded at Vic Roads, it was Dad's that got cancelled.
Oh, right.
Dad, very upset. Took 5 months to solve.
So the situation here then, what do we do?
The situation is, well, it's my view is, John, you've now got the licence problem solved, haven't you?
Yes,
You've
we
got
have.
The licence fixed.
We went back to Vic Roads, explained to them what had happened, and we did all the necessary things and have the licence has been renewed. I just wondered whether Vic Roads actually should inform
Vic Roads doesn't write to you anymore.
The licence.
Vic Roads doesn't write to you anymore. Yeah, it's now up to you to remember.
Hope that's helpful. Robin in Wonga Park, go ahead.
Oh, hello. Last year, David and Virginia, we basically got a letter on urgent repair from Yarra Valley Water saying that we had a private water main that was leaking outside our property.
It's very hard to understand, Robin. Sorry, very hard to understand you. Can I get you to ease off the microphone a bit, because you're right up against it like this? So see if that sounds better.
Okay. We had an urgent repair required, and it said that we had a private water main leaking outside our property. So I did the due diligence, couldn't find the leak, and called Yarra Valley Water to be told that it was actually 400 metres away from our property, and we had what was called a private water main or temporary trunk service, which was nothing mentioned on our Section 32 when we bought the house over 20 years ago, and we didn't really know that we'd owned a temporary or a private water main.
That you owned all 400 metres of the water pipe? Yep.
More than 400 metres, actually, because we also found out that we shared it with we live in number 11, and we also shared it with number 15, which was another 200 metres down the road, and they didn't know. So we did our due diligence, and in our Section 32, it said that the property is not subject to any encumbrances resulting from work of this authority, the Yarra Valley Water, disclosed by the title search, and there are no works, matters or anything to be disclosed. Now, I think encumbrance, and that's what I'm ringing you for, to ask your legal definition of encumbrance. It seems that if we were to convert to a Yarra Valley approved water main, it would cost us for 400 metres, something like they quoted $240,000. Which is a lot of substantial amount of money.
Incredible amount of money.
All right, so
they're right in the sense. Well, presumably their paperwork's right, in that it's a private water line, that in the same way as it would be a water line inside your property. I think that if you and the people at number 15 get together with Yarra Valley Water, I would be arguing that in part you had relied upon their assurance at the time you bought the property that it was a Yarra Valley water pipe. And if you don't get the answer that you want at that point, I would be talking to the State Ombudsman's office on the basis that part of the reason you bought the property was the Yarra Valley Water failure to adequately describe the service that serviced your home.
Okay, well, I mean, that is how I feel as well. To get the repairs done, it would have also cost a lot of money because it was under a road.
Yes.
And I went to the Ombudsman, and they negotiated with Yarra Valley Water, and they repaired the leak for us because it was quite, it had to have traffic management on the road, and it was quite the...
Yeah, but Robin, to be honest, you want to take this one step further. You want Yarra Valley Water to assume responsibility for the water pipe.
And how do we get that done?
Well, that's why I'm going to the Ombudsman. I'm saying you gave me an encumbrance certificate when I bought the property. It didn't disclose that it was a private service, and that you want Yarra Valley Water to assume responsibility for it. But I'm also absolutely terrified that 600 metres of pipe could cost $250,000.
Yeah, absolutely.
Yeah.
So where do we leave that?
Well, the answer might be she's clearly got a claim against Yarra Valley Water. The question that you have to ask, though, is how material would that information have been in the purchase? How much less would you have paid if you had known, or would you have not bought at all?
We'll have to leave you with that, Robin, and it's a very expensive one, but it actually sounds like that might be one of the rare cases where you actually need to go and speak to a lawyer yourself if you're potentially out for that much pipe. Andrew in Hawthorn, go ahead.
Oh, yes, thanks, Virginia and David. Yes, we have a driveway on a boundary, and obviously there's a fence on one side and the driveway, then the building, and we have a complaint from the neighbour saying that there's water flowing, there's water from the driveway flowing into their property and affecting their foundations, and they're claiming that Section 16 of the Water Act, that the property owner is responsible if water flows from their property to a neighbouring property. So I'm just wondering, Is it?
That certainly sounds like Section 16 of the Water Act, but the Section 16 talks about unreasonable flows of water.
Yes.
The expectation, Andrew, is that you will arrange for the discharge of all stormwater from your property to a lawful point of discharge. So
Which we have done.
Well, then there's no water flow.
Well, there is water flow because if you get because of the climatic change we're experiencing, where you get these huge downpours of rain.
Yes.
The stormwater systems really can't cope with this, and this is sort of a general problem across the board.
But Andrew, what we've got here is a problem that it is before your boundary. Right now, it's not as if it's it gets to the boundary and has nowhere to go. We're talking about something that leaves your house across their driveway and hits their foundations.
Across our driveway,
yes.
And hits their foundations, yes.
Yeah. So I'm inclined to support the view that it's an unreasonable flow of water.
Right.
Now, if it happens once a year, I'm in, but if it happens once a month...
Is that quantified somewhere, what an unreasonable amount is? Is it in litre or volume or something?
No, it depends upon the circumstance.
Shouldn't it?
Well, maybe. And then how often?
Yeah.
If it's 20 litres on one day a year, it's different from 20 litres spread equally over the year.
So what now?
There's the question as to, I think there would, if I was Andrew, I'd be trying to get some idea of the volume of water that might go across.
Right.
And I would be wondering whether there might not be some way of channeling the water down his driveway rather than across his driveway.
Andrew, we'll leave you to solve that conundrum. I hope that's helpful. Great to see you, David. Thanks so much. David Whiting there, who is your brilliant talkback lawyer, who'll be back with you next week as well.